What kind of allegations are sufficient to support a Donnelly claim? To find out, you have to read Taxi Tours versus Go New York. But it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Taxi Tours versus Go New York. The citation for this case is 2024 New York Slip Opinion 01333, published by the New York Court of Appeals on March 14th of 2024. The issue in this case is what is legally sufficient to allege a violation of the Donnelly Act, which is the anti-competition statute in New York. To understand and appreciate the context of this case, I think the helpful information to know is, first of all, the Donnelly Act, which can be found in General Business Law, GBL 340, which in sum and substance, the important part says, every contract, agreement, arrangement, or combination whereby a monopoly is or may be established or maintained, or whereby competition may be restrained is illegal. So it's anti-competition conduct or collusion or actions are what's prohibited. There's no actual obligation that everyone be allowed to win in a specific industry, but it's the regulation or the restriction on a free economy, on competition itself, that's violated by a Donnelly Act issue. The 4 elements that must be established in a complaint for a Donnelly Act violation is, number 1, they have to identify the relevant product and geographic market, describe the nature and effects of the purported conspiracy, allege how the economic impact of the conspiracy restrains the trade in the market, and 4, show a conspiracy or reciprocal relationship between 2 or more entities who are named. The failure to satisfy all those pleading requirements results in a dismissal of the Donnelly complaint. And the important part is you have to allege concerted action by 2 or more entities and a consequent restraint of the trade within the relevant market. The other thing you have to know that's helpful to understand this case is that under CPLR 3211, which is a motion to dismiss, you can move to dismiss a cause of action, a complaint, before you even begin before you begin discovery. It's not a summary judgment. It's a motion to dismiss the complaint for failure to state a cause of action. So if a complaint itself, the initiating accusatory document, fails to satisfy the requirements for the action, it's subject to dismissal under 3211. And when a court analyzes that kind of a motion to dismiss, the court has to give it accord liberal construction, accept every single fact alleged as true, and give the non-moving party, the party that filed the action, the benefit of every possible favorable inference and determine whether the facts as alleged fit within a cognizable legal theory. So what are the facts here? The facts are that there's a litigation between Go New York and Taxi Tours, and Go New York files a cross-claim. This whole thing is a cross-claim, which is a claim filed after the initial claim has been filed. And Go New York files this cross-claim, this counterclaim, that alleges that these 2 other companies, Gray Line and Big Bus Leisure Pass, are conspiring to leverage their market share to shut out any other competitors, including Go New York, from the hop-on, hop-off sightseeing business. So these buses that operate in New York City, where you can get on the bus and it'll drive you to the next stop and then get off the bus, and there's certain attractions that you can jump off at the Empire State Building or the Metropolitan Museum of Art. You can hop on, hop off. And these 2 companies, according to Go New York, have conspired with all these attractions to shut out competition. In their complaint, Go New York says that they contacted several New York attractions to try to do business and were told 2 different things. First, that the attractions said they can't partner up with Go New York because if they did, the other businesses would end their relationship with them. So if Go New York got a relationship with, for example, the top of the city, or let's say Empire State Building, then they would lose business with the other companies that do business there. And second, they said that some attractions claim to have an exclusive relationship with either Gray Line or Big Bus as a basis not to work with Go New York, but in fact, those attractions partner with the other one. So if they say they have an exclusive relationship with Gray Line, they also do business with Big Bus and vice versa, which indicates that this is not necessarily an exclusive relationship because there's multiple business engaged in it. So when they file this cross-claim, the other side makes a motion to dismiss under 3211. And at first, the Supreme Court, the procedural history here is the Supreme Court grants the dismissal, says it's insufficient allegations to show a conspiracy. The appellate division affirms that dismissal, and it goes to the Court of Appeals, and they reverse. They say this was sufficiently pled. Those allegations in the complaint are sufficient to allow the case to continue, where you can actually get discovery. And the issue here is they say it can be inferred that the claimed exclusive relationship was in fact a pretext to cover for the anti-competitive efforts to exclude Go New York. And the point is that without having the case move forward, you can't get the discovery. You can't get depositions. You can't subpoena records or emails or text messages that would actually substantiate it. If you throw it out at the complaint stage, then you can never develop the case further. So those specific allegations are sufficient, and that's the case of Taxi Tours versus Go New York. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.